Subsequently, while he was absent from this court, an advocate was representing him, appeared in court and presented forged documents, medical documents. Meant to mislead the court and to explain the accused person's absence. Your Honor, the investigating officer wrote, the officer of the DCI wrote to Kenyatta National Hospital who confirmed that the said letter that had been presented, dated 3rd of February 2024, did not originate from the hospital, and that the consultant physician who had signed the purported letter was actually not an employee of Kenyatta National Hospital. Then I have the three letters which will be producing in court. Your Honor, the investigating officer has also sworn an affidavit that is Inspector Robert Matunda. Will also be producing the same affidavit. Your right to bail is not absolute and can be limited by the court.
Mr. Waso, Your Honor. Yes, Your Honor, we wish to maintain the quorum as it was. Bully and Mr. Dagai. Yes, Your Honor, perhaps maybe before we make the application, it seems there is, the prosecution has some documents and an affidavit which she has been referring to, and we don't have it. I don't know whether you will advise how to proceed, because it's important that at least as we respond to the issues which look to be factual and sworn by the investigating officer, it's good that we also have a chance to look at the affidavit, yes, so that we can. Yeah. So, Your Honor, I don't want to look as if I'm wasting the court's time, but I will request for at least 10 minutes to get this further instructions, because I'm seeing allegations of certain documents here, and it would be unfair for me to proceed with responding to a question that, as counsel on record at the moment, I may not be aware of. So perhaps you grant us only 10 minutes, strictly, so that, yes, so that I can be able to share this with my client and get instructions so that we proceed properly, if you may indulge me. Because it's just some.
I already given them 2 hours,
Your Honor, you see,
she
gave us 2 hours, but the DPP saw us here when we were seeking that adjournment, and chose not to give us the affidavit. Yeah, what was the reason to hide the affidavit? Surely.
We can give them some time.
Yes.
10 minutes, strictly 10 minutes.
That's okay.
Confirm
Yes.
10.
Thank you.
That is at around.
Yeah. We'll make sure we keep time.
Yes, please.
Thank you.
So help me God. Your Honor, in this matter, I'm the investigating officer together with my colleague, Inspector Josephat Kimani. Your Honor, this matter was reported at this headquarters by the complainant with Inspector Josephat Kimani. Your Honor, this matter was reported at this headquarters by the complainant, accusing the respondent this matter that he obtained money by false pretense, in that he was in a position of selling him jewelries. We commenced investigation, Your Honor. We completed our file within a period of 1 month. And we managed to arrest the respondent in this matter. And Your Honor, during that arrest, the respondent requested our office. We called the complainant, and then they agreed together so that he can refund the money. The respondent was given time up to a maximum of 7 months. Your Honor, he failed to refund back the money. He went missing. We made effort and rearrested him and booked him at Mutaiga police station. Your Honor, he further requested that be given a bond, a cash bail, sorry, Your Honor. He was given a cash bail of 100,000 and directed that to report to this court for pre-taking on 6th February 2024. Unfortunately, Your Honor, the respondent failed to report to court. Instead, his advocate appeared before this court
He was to report on which date?
on 6th February 2024. Instead, Your Honor, his advocate appeared in court with a document purported to originate from Kenyatta National Hospital that the respondent was given a bed rest. Your Honor, the court directed us to establish the authenticity of the document. We wrote a letter to the Kenyatta National Hospital. I'll file the letter in court. And then, Your Honor, Kenyatta National Hospital replied by saying that the document was not genuine and it did not originate from their hospital. And even, Your Honor, the person who issued the document, who's purported to have issued the document, was not the employee of Kenyatta National Hospital. After that, Your Honor, we tried to summon the advocate in question to our office. He went missing up to now. His phone is off, but efforts are still on to trace him. Your Honor, it is in record that my co-IO has been in this court to answer summons as to why we have not arrested the respondent in this matter. I want to put it clear that, Your Honor, the respondent switched off his 5 mobile phones. That made it very difficult for us to trace him. This court issued a warrant of arrest. The cash bail was forfeited. And, Your Honor, from the investigation which we have carried out, the respondent is not a person you can trust. He keeps on giving false promises. Your Honor, it is up to yesterday when he was found committing the same offense of obtaining money by false pretense. Can I proceed?
You are on oath, but remember you're not giving evidence. As such, you are supposed to be supporting your application why he should not be given.
Yes, that's what I'm doing, Your Honor. Yes.
Proceed.
So, Your Honor, it is up to yesterday that he was found engaged in the same offense. He was arrested by background officers, and that's when we were called. We had arrested him and presented him to court. To finalize, Your Honor, I'm very much aware of the Constitution, Article 49, subsection 1H, that the accused person cannot be denied the bond or cash bail. But I'm saying this, that if given the cash bail or bond, he cannot attend the court proceedings. That's all, Your Honor.
Why would they be worried about us confirming the issues we have said here? What is the worry? Because most of the things you have said here are not factual, and we want the court to understand those issues. I don't think there should be an issue. If we bring a witness, the DPP has the right to examine our witnesses, so that to make sure we are guiding the court properly, helping the court to come to determination. I don't think there should be a problem asking a few questions on the issues raised. There was a counsel who appeared before this court with a document from KNH.
Correct.
Correct. And you did that verification of those documents, and we are happy to see that we are response from KNH.
Correct.
Maybe we want to know what was the name of this council?
I cannot remember him.
Were you in court?
My colleague was in court.
Does he remember the name of the council?
Maybe we ask him.
You don't know. You don't remember.
I cannot
No,
remember.
you are on the stand. We are talking about you. We testified.
I cannot remember.
You can't remember.
Yes.
After realizing or getting a response from KNH, as a seasoned officer, as per your number, I can tell by your number, a seasoned officer, what action did you take against that council for bringing a false document before this court?
I think if you listen to me carefully, I said that the counsel went missing up to now.
Council?
The advocate, yes. So we are making effort to trace him.
Since February?
Yes.
A council?
Yes.
Are you aware you can search a council by just a click online and finding even his impression?
Might be was a street council.
Have you written anywhere to the law side of Kenya, a letter, law side of Kenya, trying to raise this complaint and looking for counsel?
Our major aim was to trace the, no, our major was to trace the suspect first. No.
No.
Yes.
That is the answer I'm looking for. You also indicate that cash bail was forfeited before this court.
Yes.
When? Yes.
And there are certain things which are facts.
Yes,
If
Your
it was
Honor.
forfeited or not,
Yes, Your Honor.
there is court record.
Yes, I'll peruse the file, and I'm putting the question because I perused the court file. So I'll want him to confirm the same, because from the what I perused, I seem not to see such an order of forfeiture. Unless we're dealing with another file.
It was on 4th March 2024.
Before this court?
Yes.
4th March?
Yes.
In the court will confirm that with us. Thank you for your answer. Lastly, the last question before this court. At any point did you interview the accused person's mother?
The accused?
Person's mother?
No.
You never interrogated anyone?
No.
In his family?
No.
Never?
Never.
You also say lastly, if you allow me just one more question. You indicate that you were called yesterday at Parklands Police Station after your arrest over, in quotes, a similar offense.
Yes.
Are you aware of offenses that brought you to class proceedings yesterday?
Obtaining, yes.
Are you aware that the things that those complainants were asking for were returned?
I'm not aware.
You're not aware?
Yes.
Have you seen a file before this court over those offenses?
Which offenses?
The ones we're talking about?
They have?
Have you seen a file here has been brought a charge?
Maybe they sorted it out there.
Yes.
Yes.
So you're not aware about whether it was sorted or not?
Yes, I'm not
You
aware.
don't know?
Yes, I'm not aware.
Thank you very much. And further questions? That will be
The accused person is a flight risk. True?
Yes, true.
But you confirm that you picked him at Parklands Police Station.
After a period of more than 7 months.
Just listen.
Yes.
You confirm you picked him?
Yes. Yes.
So it is clear that you did not carry out your investigation because he walked to Parklands police station.
Negative.
And he was not
No,
arrested.
you are misleading the court.
Just answer
That's
the
not the
question.
question. That's not the position.
Listen to the question. You picked him at Parklands police station.
No, I will not pick him.
Are you listening or you are answering?
I'm answering the question.
Okay, listen again. Please confirm that you picked him at Parklands.
Negative.
Where did you find him?
Parkland police station.
You don't have no further question.
Prosecuting counsel, probably you have a
And you responded no, but you take back something else. What did you reply?
I wanted to say that I've been away for some time. Maybe my colleague, the two are you in this matter. I'm not aware whether he has responded the ELSK or not. But me, I'm not aware of that.
Yes, you have been asked by counsel whether you picked the accused at Parklands police station.
Sorry?
Whether you picked him, whether he walked to Parklands police station.
No, he did not walk. He was arrested. He was arrested.
So did he walk to the police station or
No.
you wanted to explain something? What did you want to explain?
No, I was trying to explain that the accused person was found somewhere committing the same offense of obtaining. That's when he was arrested. He did not walk to the police station.
Of the Constitution. Your Honor, the accused person is a Kenyan citizen who lives in Nairobi, to be specific, with this young family. He stays in Westlands, General Madenge Road. The accused person is not a flight risk. He does not intend to and will not interfere with any witnesses in this matter. Further, Your Honor, the accused person undertakes to attend this honorable court as and when he is going to be required. Lastly, from me, Your Honor, the purpose of bond is to secure the attendance of the accused person to this court. We have had factual issues which have been raised by the prosecution team. One factual issue is on the issue of taking bail on the taking plea on the 6th of February 2024, which did not take place for medical reasons known to this court. And we wish to refer to one of the documents which have been served to us by the prosecution from Kenyatta National Hospital, drawn by the CEO, Dr. Lydia Maingi, I believe, which states in the second paragraph, we have a document dated 9th of February.
That's a letter.
A letter, yes, Your Honor. 2024.
Dated
9th of February 2024. It's a response.
by Dr. Maingi.
Dr. Lydia Maingi. Is that doctor? Lydia Maingi, I believe. Yes, Your Honor. In the same letter, she acknowledges that the accused person was registered for treatment at KNH. We can confirm. He was registered on the 6th of February 2024 at 4:07 p.m.
On what date?
On 6th of February 2024, 4:07 p.m. 7 minutes past, Your Honor. It is a fact that the accused person has a medical condition, and that is why he was not able to take plea on that particular day, Your Honor. Your Honor, the prosecution team has not given us compelling reasons on why the accused person should not be admitted to bail or bond. They have made allegations, what we consider to be allegations, against the accused person, unfounded facts, and given flimsy grounds. The complainant and the accused person are well known to each other. They lived at one point together as girlfriend and boyfriend. And it's a matter which the accused person,
You know, those are facts, huh?
you know, there's somewhere I'm going with it. And there has been attempt to settle this matter. We call upon you to admit the accused person as a matter of right under Article 49 of the Constitution to cash bail and where in the alternative this honorable court feels like it is not convinced by our submissions, the law, I believe, is very clear on alternatives which the court can set, alternative conditions which the court can set for the accused person to meet. In this case, bond might suffice, Your Honor. That is all from me. I welcome my colleagues to put in a word or two.
Are not clear. As far as the facts are concerned, therefore we'll be asking that this court disregards the testimony by the investigating officer who has clearly, before Your Honor, failed to convince this court as to whether he has compelling reasons to limit a citizen's rights. It is clear, Further Your Honor, that the investigating officer failed to do his job. Therefore, cannot come before this court and seek assistance in conducting investigations. Lastly, Your Honor, on my side, as my colleague has indicated, Your Honor, the investigating officer has failed to disclose before you that there have been attempts to settle this matter. And even as we are appearing before you today, now, the complainant is holding the accused person's diamond worth 5 carats. That's amounting to around 4.5 million as per the market value, as security for the monies lent to him. Accused persons, a diamond, yes, 5 carats, valued at the market value of around 4.5 million, as security. That is something the IO and the prosecution have intentionally left out with the intentions known to them. Clearly, the IO is not in conduct of this matter. Therefore, Your Honor, will be praying that you affirm our client's rights to bail and bond. And issue terms for his attendance for the hearing of this matter. And lastly, the accused person has never jumped bail from this court or any other court in this country.
Wanjala Sifuna, that at paragraph 13 of the said petition, number 14 of the yes, Your Honor. The Superior Court was grappling on the issue of what compelling reasons are. That I believe is the issue before you. So at paragraph 15, the court asked itself the question, but what does the term compelling reason mean? So I just pray that the court allows me to read paragraph 16.
You have the authority to do something?
Yes, I have the authority, but I think I can.
Online, huh?
Authority is online.
You can supply.
Can supply to the court.
It's okay if you could supply. I know my problem is, just in case you've misquoted and I don't understand it.
Okay, I will. Who will supply it?
Say to the court of grappling with the term compelling reasons.
Yes.
Then just read at paragraph
16. So the court said the term has been used in other jurisdictions to mean exemptional circumstances or unusual and extraordinary circumstances. So the court went all along and I can just submit on that part. The matter that is before you, Your Honor, there is nothing that is unusual or extraordinary or beyond the obvious. The accused person was picked at a police station where he had gone to sort out other issues, which he sorted out. The accused person's place of residence is known, and he submitted himself to this court. And therefore, the notion that it's a flight risk, clearly, Your Honor, it has to fail. On that limb, Your Honor, we believe we have made our submissions, and we pray that the court exercises its discretion and grant the accused person bail. Thank you.
The accused person was well aware that there was a criminal case pending, and he never bothered to follow up or avail himself in court. It has taken 7 months for him to be arrested and brought to court. Your Honor, I submit that we have given compelling reasons for the accused person to be denied the bond. Your Honor, the failure of an accused person to accept bail of bond terms on previous occasions is a compelling reason to deny bond, Your Honor. The accused person is also not police custodial, and the file was registered in January, he failed to attend court, and subsequently filed the arrest position. Your Honor, Mr. Wish to submit that it's a flight risk, having absconded for 7 months and failed to appear before this very court on previous occasions. We are apprehensive that he is granted bail bond. He will not appear in court. And the complainant has always appeared in court. Prejudiced. Another incident of which the person is charged with happened on the 17th and the 17th January 2023. Between January 2023 and 20th February 2023. It's now 1 year and 7 months from the time. And this is a matter that would have been had expeditiously and concluded if only the accused person had showed up. Clearly, any attempt at settlement or also absconding from court shows that he has just been employing delaying tactics in an effort to frustrate the complainant, Your Honor. Your Honor, we also wish to refute the allegations that the complainant was in a relationship with the accused person. They were not in a relationship, and they were actually only friends. The complainant is also not in possession of any security, as alleged by the defense. If she had any security, she would not have filed this matter in court, Your Honor. Therefore, submit that you have given compelling reasons, Your Honor. As the court records, you also bear me witness. Your Honor, the accused advocate, one of the accused advocates presented a letter, a fake letter from Kenyatta National Hospital, There's also a letter dated 9th of February 2024, which the defense counsel has referred to partially in an effort to mislead this court. February, there's a letter dated 9th of February this year, addressed to the Director of Criminal Investigations by the Chief Executive Officer, Kenyatta National Hospital. The second paragraph reads that the accused person was registered for treatment at Kenyatta Prime Care Center on the 6th of February at 4:07 p.m.
Registered for treatment
at Kenyatta Prime Care Center on 6th of February 2024 at 4 p.m. However, the letter notes that when he was called into the consultation room at 4:10 for examination and treatment, he was not available. Therefore, we submit
when he was called into
the consultation room at 4:10 p.m. for examination and treatment, he was not available, Your Honor. The letter also continues to state that the author of the letter dated 3rd of February 2024 Dr. Mwangi was not an employee of Kenyatta National Hospital. Therefore, Your Honor, we submit that the accused person was not treated at Kenyatta Hospital, and his visit there was probably for fraudulent reasons. He has also not produced any other medical document from any other hospital that he may have attended for treatment. We ask this court to note our sentiments and deny the accused person's bond.
Let's come back on 22nd at 2 p.m.
You know whether could we have an earlier date?
No, it's not possible for the court. On 22nd at 2 p.m.
Much obliged. But the ruling that the copy of